Chapter 3 Circumstances which mitigate criminal liability. Article 13 Mitigating circumstances. The following are mitigating circumstances. Number 1. Those mentioned in the preceding chapter when all the requisites necessary to justify the act or to exempt from criminal liability in the respective cases are not attendant. Number 2, that the offender is under 18 years of age or over 70 years. In the case of the minor, he shall be proceeded against in accordance with the provisions of Article 80. Number 3, that the offender had no intention to commit so grave of a wrong as the committed. 4. The sufficient provocation or threat on the part of the offended party immediately preceded the act. That the act was committed in the immediate vindication of a grave offense to the one committing the felony, his spouse, ascendants, descendants, legitimate, natural, or adopted brothers or sisters, or relatives by affinity within the same degrees. 6. That of having acted upon an impulse so powerful as naturally to have produced passion or of suffocation. 7. That the offender had voluntarily surrendered himself to a person in authority of his agents, or that he had voluntarily confessed his guilt be, be- before the court prior to the presentation of the evidence for the prosecution. 8. That the offender is deaf and dumb, blind, or otherwise suffering from physical defect, which thus restricts his means of action, defense, or communication with his fellow beings. 9. Such illness of the offender as won't diminish the exercise of the will power of the offender without however depriving him of consciousness of of his of his acts. 10. And finally, any other circumstances of a similar nature and analogous to those above mentioned.